Hail to legal warriors. A question that I often get is, why would a prosecutor decline to file charges in a domestic violence case after someone gets arrested? So many people call my office wondering if they're going to get charged. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, as always, I'm just going to jump right into it. What do I mean in this type of situation? A prosecutor declining to file a charge. What does that even mean, Lance? Well, in this state, in Washington state, if a police officer shows up within 4 hours of an assault, which is a very broad term, involving family or household members. Assault means anyone wanting touching, pushing, slapping. It could even be threats sometimes. Then an officer has to make an arrest. And depending on the type of law enforcement officer, they may or may not have power to actually charge the person they're arresting with the crime. There's other videos I talk about in this channel about that distinction, but think about it this way. If it's a city police officer arresting someone for a non-felony domestic violence case, oftentimes they do have the power to charge the crime themselves into court and not wait for a prosecutor to make a decision whether or not there's going to be a charge. Now, a lot of people don't live in city limits. They live in unincorporated areas. It might have a name like Linwood, but they might be outside of the incorporated city limits. And those people usually are serviced their homes by sheriffs. Now, a sheriff, let's say Snohomish County Sheriff, King County Sheriff, they typically only have the power to arrest somebody, not file the actual criminal complaint into court. And in that case, there's going to be a charging request or a charging decision sent to a prosecuting attorney for them to decide to file charges, or the word I used before, decline to file charges. And even some cities are like that. More often than not, City of Seattle cases are sent to the prosecutor to make a decision about to file or decline. And it gets really confusing for people. So if you get arrested for an assault charge and you don't have a court date that's called an arraignment, there is a case at a prosecutor's office where a prosecutor will get around to making a decision to charge a crime or to decline to charge a crime. And that's going to take weeks or months, sometimes a year or more. I've seen it take 2 years recently in Snohomish County specifically. So hopefully that's clear now. When I say what would make a prosecutor decline to file a charge, there's been an arrest or an investigation. The officer either chose not to or did not have the power to file the charge, the complaint themselves. They could arrest on a probable cause hold, but they couldn't file the charge. And now they send it to this prosecuting attorney's office to make a charging decision. So what factors does a prosecutor look at, and why might a prosecutor decline to file a charge against somebody who is arrested for domestic violence? Because many of the people that call my office, it might be the loved one, the alleged victim of the case might call, it might be the person who got arrested, and they want to know, am I going to be charged? And we can do things to try to improve the chances of a prosecutor declining to file a charge. So a prosecutor looks at a bunch of things. Number one, they're going to look at the actual fact pattern of the case. That's the most important thing. What is in the police report? Is it sort of a small or a de minimis matter? It was just a push or a shove? Are there any injuries? Was it a really aggressive one-sided situation, or did both sides sort of push and shove until the officer had to make an arrest for only one person? Were both sides involved? And how scary did it look or sound? Are there lots of threats being made in the report? What are the injuries like? That type of thing. And so they're going to look at the report, and the more it sort of makes them mad, the prosecutor, the more it makes them scared, the more likely is they're going to file the charge and not decline. What else are they going to look at? Well, they're going to look at how long it's been, right? Is this case been around for 3 months, 6 months? Are they only getting to it 9 months later? They're going to look at the length of time that's passed as a factor in deciding what to do. And also, like, has anything else happened in that period of time? Have there been more police reports? Have there been more times the police have been called up? Has there been another arrest? And Of course, time is not something that necessarily should be considered, but it is. I was a prosecutor 7 years. If it's a close call and it's an older case and not much has happened, well, that leans more towards a factor that weighs towards decline versus charge. What's another factor? A third factor is, what are the wishes of the victim? Okay, it is not the victim's charge to press or not in Washington state. Whoever the victim is, they don't get to decide prosecute or not. It's the government that gets to decide that. It's the government's case. But some prosecuting agencies will listen more to what the alleged victim wants than others. I think City of Seattle usually listens. The county often, Snohomish County wants to get their victims on board. And so while the alleged victim cannot have the power to make the case go away, if the alleged victim is sort of telling the prosecutor, I don't want it prosecuted, that weighs towards declining as well. Also, can they even reach the alleged victim? Is the alleged victim in the wind, so to speak? Are they missing or they're not responding? Well, sometimes a prosecutor gets really frustrated. Well, hey, if this alleged victim doesn't want to cooperate, why should I file a charge and have to chase the victim for months and months and months on going forward with a case that they may not want? So that's another reason why a prosecutor might decline to file a charge. A fourth reason, well, they're going to look at your prior criminal history, right? You have a string of priors, well, they're more likely to file it regardless because you're just not learning your lesson, whoever the defendant is. If someone has no priors at all, and all the other factors sort of combine, then it leads towards maybe they don't file it. Maybe that's another reason they would decline. I think the fifth reason would be defenses. Are there any obvious defenses that they're worried about defeating? Right? Is there a self-defense claim that's very clear? Does it look like there's a defense of that I was only defending myself because the other side was drunk? Right? Is the other side drunk? That type of thing. What are the negative factors that the prosecutor is going to have to face in this determining whether or not they're going to file a charge or decline to file a charge? So those are some reasons, but I want to jump into something else here because so many people make these mistakes. How do you know if a prosecutor declines to file a charge, and what does that even mean if they decline to file a charge? Well, the only way you're ever going to know if a prosecutor declines to file a charge is typically an attorney calls up the prosecutor's office, usually the front desk, and asks some questions. Hey, is this case still active? Who has it assigned to them? That type of thing. Now, if you do it yourself, I want you to be careful because you don't want to accidentally trigger some person who answers the phone to get somebody interested in your case that's actually a prosecutor. Oh, this one's been sitting around. Maybe I'll get to it now. Because remember, time might be on your side. So we don't want to ring the bell and get them looking at your case. So attorneys that are really experienced, like my firm, we're going to know who we can call and who we can't and what we need to ask and not ask to try to find that out. Occasionally, the alleged victim may get a letter saying that, hey, charges have been declined. And you might learn that from the alleged victim, but that's not super common practice throughout the state. There's a few agencies that do that, and they don't do it super consistently, but that can happen. So again, the attorney probably has to find out for you. And what does it mean? Does it mean you're off the hook forever if the prosecutor declines the charge? Well, yes and no. Yes, to the degree that once the prosecutor makes a decision to decline, they're not likely to look at it again, right? It's out of the system. It's gone, right? I declined to file charge. I used to enter declines when I was a prosecutor. However, it doesn't preclude them from changing their mind if your case is still within the statute of limitations. The statute of limitations is how long the government has from the date of the alleged violation to initiate or file a criminal case against a suspect, a defendant. For non-felonies, most of them in Washington state, including domestic violence, for non-felonies, that's 2 years. So let's say they look at your case at the 8-month mark, they decline it. Good, we're done. Well, not if something else happens. Let's say they declined it from lack of victim cooperation. And now the victim is mad at you 16 months from the date of violation and starts calling the prosecutor, I want this thing filed, right? All these other things happen. Nothing stops the prosecutor from reopening their matter and now filing the charge because a decline is just an internal process, right? Where, hey, we're not going to charge it, but they have the right to change their mind until the statute of limitations runs. So if you get a decline, you learn something good, don't upset the victim again. Don't be, writing about it on Facebook or things like that where you can, possibly change such a positive outcome. You don't want to do something that makes the prosecutor reconsider the whole situation. What else might they look at to reconsider? Well, if you got another arrest, right? We see that all the time on different types of cases. Well, hey, we declined to file this one charge, but they got arrested again. Now let's use both. Okay, let's use both to get more leverage because this person isn't learning. So a decline is great. There's lots of reasons why a prosecutor might decline a case in a domestic violence matter. I've covered some of those. And most importantly, what you want to do is get yourself an attorney if you are facing a situation where you've been arrested or investigated for domestic violence, because a good attorney is going to sort of know the home field of what each prosecuting agency does and doesn't do. And because you can't go into this blind, okay? You don't. It's just too serious. It's such a serious problem. Domestic violence shouldn't happen. I hope it doesn't happen, but this is an informational video to let you know reasons why the prosecutor might decline and what the pitfalls are. So if you found this useful, please like and please subscribe. More people get the help they need. And more importantly, if you have a legal problem in Washington State, feel free to reach out to my firm. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.